interview. Okay, so I explain what and why. Okay, next slide. Okay, this is a process that you will have to go through. Lawyers will have to go through. Okay, no matter whether they are in a corporate doing real estate or litigation or any kind of legal advisory that they have to provide. So it's a process of meeting. Okay, definitely you have to meet and get to know your client, okay, and understand his case better. So that's where we have this client interview. Okay, it's a process where you extract all the relevant informations, maybe not all, okay, but the relevant informations or preliminary relevant information regarding the client's matters, okay, to provide you an analysis of the situation, of client situation. Okay, you are supposed to extract our information and then you will not peel out, but you'll form an from the facts, then you form a view or your opinion whether how strong is client's case. Okay, and then this is where you advise client based on the information that client give you. Okay, next slide. Okay, so please remember, client interview is not a chit chat with client. Of course, there may be small talk. Okay, you may ask about some the everyday question, everyday topic is no problem, but you're not going. But just remember, you're not going for chat. Okay, so the purpose, then you must eventually be able to extract all the relevant information so that you can form an opinion to advise client accordingly. So to put it summarily, okay, it is a foundation, okay, for your future conduct of the case. So it is also from there that you will decide whether you want to take up, okay, or not. Okay, this stage, you are not being retained yet. There's no retainer yet. It's after this, after the client interview, then only client will decide whether they want to retain you or you really want to take up the case. Okay, next slide. So there are some principles to hold on when interviewing clients. So these are the principles. Okay, so they will say, okay, who's actually in control during this client interview? Remember that you are there to provide advice, okay, to take facts and to provide advice. So you are in control. But when you are in control, doesn't mean that you make the decision for client. So eventually, client is the one who makes the decision. So let's say you are there to provide the advice so that client can make an informed decision. Let's say client not sure whether they want to go for divorce. Okay, so you will explain there. Okay, what will happen in the divorce. Okay, so client is the one who makes the decision whether after he hear you, after he listen to what you advise, they still want to go proceed ahead with the divorce. Okay, so the decision is with client, but you are in control. You are not there to take instructions. Okay, you are not there just to take message. Okay, so you are in control. So when you go there, you have to be equipped. Okay, so which we will discuss later. So principle number 3, understand some psychology. Okay, yes, this one you have, okay, some emotions, okay, especially when dealing with family matters, employment matters, yes. This one will be involved, relationship matters, yes. Okay, so you go there, you just don't just say, you're not just to pick out what the law says about this, okay. So eventually you still have to relate back what is the client's problem, the law, and the how it applies to the client's situation. Okay, you're not just say section what says this, so what. Okay, you have to connect that to the facts, the client's case lah. So anticipate common problems. Okay, you go there not to just take down facts, but you will anticipate, okay, what are the common problems, possible questions that client will ask. So be prepared. Okay, you're not just there to take note. Okay, so this will be discussed later. Just right now, just the principle first that show that you have a structured approach, how you will advise to go about the case. Let's say that's where you can strategy. Let's say you first file this application first, then after that you go to that application, then only you go for, okay, or in the middle, you will start a negotiation for settlement, let's say, okay, not at this stage, then you go a little bit later, then only you start the negotiation process. So there's a structured approach that so client will have the confidence in you, okay. So another one, principle number 7, show that you are ethical and professional, not taking the shortcut. So no, you have the principle. So this way, ethics and professional is important. Okay, so these are the principles. Okay, that remember when you go in for a client interview. Okay, next slide. Okay, we'll go through 3 matters later, 3 areas of practice, but this one is a general guide. This one is family, later is personal injury, and then for employment. Okay, three areas. So next slide. Okay, family, when we mention family matters, it will involve, usually will be divorce, okay, and the terms of divorce, okay, such as the custody, what will the arrangement of custody, maintenance of wife and children, asset distribution, property, how, okay. Family matters not only in limited to divorce, okay, in wills also considered family matters, probate, die already, so how you are going to, okay, proceed, probate or letter of administration, adoption, okay, and citizenship. Okay, citizenship we may not deal, but there are a lot of cases out there on citizenship matters. So it is important that, okay, you are dealing with all this, so you must familiarize yourself with relevant provisions of the law. Okay, that's where when you go to a client interview, you must be equipped. You must at least know the basic the basic. Okay, not the whole provision of law reform, but at least the basic sections. Okay, so like a law reform section, the section 51, 52, 53, 54, 88, those you have to familiarize what are the provisions. Okay, because your advice will revolve around these sections. Okay, Wills Act, Probate and Administrations Act, what you can do, what you cannot do. Sure, the executors will ask you, okay, what I can do, what I cannot do. Okay, letters administration also, no will. Okay, so who is going to apply? All this is provided under the Probate and Administration Act. At least the okay, relevant sections like Wills Act, rules of court, yes, how you're going to go about to apply, what are the process, okay, and also the regulations. Like law reform, you have their regulations. Probate Administration Act, okay, they have their regulations, the subsidiary legislation. Okay, so these are the basic laws that you have to familiarize. Okay, we have all this. Okay, now we have this. Okay, if not in under the soft copy under the CLJ, okay, we also have this. Okay, you can always search for this and read. Okay, next slide. Next slide, Mike. Okay. You always start with requesting client to tell his, okay, after your small talk, then okay, go to the facts. Okay, you get client to tell the facts of his case. Okay, what happened. Then you also, sometimes you can also request client to draw a detailed chronology. If it's very long, okay, long story, then you will ask client to draw a chronology of events from what day, earliest date to latest date. Okay, what happened in between, what happened. Okay, so this like can be a chart, can be a list. Okay, so you can keep that. Okay, then you, in the meantime, I mean, in between, you can always prompt client with questions lah. Now, what about this? Okay, what happened next? Okay, it was always a non-leading questions lah. Okay, so at this stage, you will let client talk. Okay, well, for family matters, client will need to talk. Okay, tell his story. Then from there, you gather the facts. And also get the name of client spouse, okay, to determine if there's any conflict, if you have to act for client. Most probably for, let's say, for family matters, there won't be much conflict, but still it is good to know who would be the spouse, okay, who are the opposite side, if they did not agree to joint petition. If joint petition, then no issue lah, okay? But if this one, okay, his spouse doesn't agree to divorce, then you will need to know who are the other side, okay, if you have to act for the client. Okay, next slide. So these are the basic, okay, most probably they will have to ask, okay, how long client was married. This is important. Okay, and this also provided under the Law Reform Act. Whether marriage registered in Malaysia, this is also relevant because if it's not registered in Malaysia, can you apply the Law Reform Marriage Act for application for divorce? You can't. Okay, so if you can't not even register, then you cannot act for them, or at least you have to ask them to register first. Okay, under the Law Reform that act, the provisions, then only they can proceed to divorce. Okay, how many children? Okay, how old are the children? This to determine custody. Okay, because once they're under 18, minor, they are still under custody. Okay, whether they are still staying together as at that moment lah. Okay, as at the interview, whether they are still staying together or have to stay apart. And if they have stayed apart, then how long they have stayed apart. Okay, because all these are relevant, you need to stay apart for 2 years before you can proceed. Okay, if they are only separate for 1 year, then you can't. If they was only married for 1 year, then also you can't go for divorce. Okay, so these are all the relevant questions. Normally you will need to ask this. Okay, if they are they are considering for divorce, it doesn't matter whether it's joint or single, you need to know these basic questions. Okay, any question is at this stage before I move further? Okay, all right, proceed further. Next slide. So when client is telling his story, okay, you're not just there, check, okay, so you start to identify what's the problem and issue already. And then you clarify with client what relief he intends to get. Okay, if let's say he come for family matters for divorce, he may not be asking for divorce, he only want custody. So can you proceed? Can you get custody without going for divorce? So these are basic questions that you need to know, okay, when you are considered very basic questions, then you need to know before you go for the client interview. Okay, so for information, yes, it's possible. You can always get custody without going for divorce. Okay, this is not a precondition. Okay, summarize your understanding of client's problem. That means after hearing the client finish telling his story, then you have to summarize. Okay, if, just to get the idea of what he intends, and then at this stage you can mentally generate already theory supporting the possible legal claims, whether he will have a case to go for divorce, or let's say single petition, whether he has a valid ground to go for single petitions. Okay, because if single petition, it means one party want to get, one party don't want to divorce, you have to certain criteria under the law and Law Reform Act that you have to satisfy before you can get a decree of divorce. Okay, so you explain that after you generate the theories already, then you explain the process. Okay, let's say if he want to get the divorce, okay, he want to join, okay, he want to go for joint divorce, okay, that means he and his client both agree to divorce, then they can go for joint petition. Okay, the terms all agreed, no issue, so they can go for joint. Or single petition, that means your client want to divorce, the other side don't want to divorce, okay, his spouse don't want to divorce, then you can go for single. So what's the process if you want to go for single? What is the process you want to go for joint? Okay, so these are the process. The process is all in the Law Reform Act, then okay, which you will need to familiarize yourself. Next slide. Okay, so if parties cannot agree to divorce, okay, before you file for single petition, you need to go for the conciliation process at the JPN. Okay, conciliation process is provided under the Section 106 of the Law Reform Act, that it is parties where the GPN, the officer, will try to conciliate both parties, whether there are still chances of them getting back. Okay, I mean, not going for divorce. So it's just another process lah before you can really go to court to get the order. So it's mandatory, okay, if parties do not agree for divorce, okay, unless you file joint petition, then you can exempt from this. Okay, otherwise you need to go through. So you need to explain this, okay, how long they will stay, how many appointments you will have to need to go. And then client agreed to divorce. Let's say if did not agree to divorce, GPN. Okay, then only court. If agree to divorce, then they can straight away file court already. But you need to get the process, okay, from filing, hearing, service, then hearing. Okay, how long? Usually it's about, last time I did was about 6 months, okay, depending on how would you manage to get the exemption. Okay, you have to serve on the biological father. Let's say no, sorry. Uh, you have to get file a statement, okay, where if the child is below 7 years old, there's this procedure you have to do before you go for final hearing, okay, to get your decree. So once you get your decree, it's a decree nisi ini. Decree nisi means it's not absolute yet, okay. It's a decree for divorce, but it's not absolute. Okay, then after that, 3 months down the road, then only you get it absolute. Then you file a decree absolute. So that's how the process, okay. It will take about 6 months to 9 months, okay, depending whether how long is the court fixing the date lah, okay, how long can the court give the date. And the estimate fees, okay, so at this stage you get all this, okay, explained to client already. So it's there then up to the client whether he wants to agrees to appoint you. Okay, so if he agree, then that's where you prepare your retainer. Maybe not at that point of time, okay, you need to prepare and draft your retainer agreement. Then you will forward to him lah. Okay, usually take a few days, then you forward your retainer agreement and warrant to act. Okay, this one, retainer agreement and warrant to act lah. In last session I've already explain this to you, right? So you need to get client to sign this. Okay, then after the retainer, you will need to communicate client from time to time to get further information. Okay, to file. If client needs more information from you, needs more explanation from you, then you will need to communicate with client lah. So communication with client is continuous, like it's not just this process only. But this one is a crucial process lah. That's where client agrees whether they want to retain you. Okay. Next slide. Next slide is personal injury. Before we go for personal injury, is there any question on family matters? No? All right. Okay, next slide. Okay, this one was for personal injury. Okay, running down. Okay, running down is accident case. Okay, car knocking another vehicle. Okay, vehicle knocking another vehicle. Okay, causing injury to the driver. Okay, so then the driver claims lah from the driver who knocked him. Okay, so then they come to see you. Okay, you need to have the interview. Okay, you want to claim. So if your accident happened recently, then your firm is able to control the case from point forth. It is always good that if he is just happened, okay, then you quickly get a lawyer and not wait until quite some time, okay, because for running down, just for information, running down, the limitation is very short, okay, instead of 6 years is 3 years. So you quickly have to, 3 years very quickly will pass, okay, so you have to take action, then take it quickly, not until limitation period is coming, okay. So if client sit on his case, then you might feel that the client may have already compromised his own case. Sure, the defense will raise this, okay, limitation period. Okay, so next slide. Then you run a conflict search. Okay, this is very imperative step in any personal injury claim. Also, not only in personal injury, any litigation matters that you do, you need to run a conflict search, okay, to make sure that we are not suing our own client, okay, we won't end up suing our own client. So obtaining the client's name, clients who are the other injured parties, let's say there are other passengers sitting at the back, or okay, they are also injured, so they get their name also. You also get the name of the other car, okay, who knocked into your car, okay, the name of the defendant, okay, to see if there's conflict, if you have to act for the client. Okay, so next slide. Before that, yes. So circumstances, then you need them client to explain to you what happened, okay. But this after you are sure that there's no conflict, okay. If otherwise, if there's conflict, then you don't have to, okay, go all this already. So you can begin to obtain, okay, this information. Circumstances of the accident is very important. Let's say what happened on that day, okay. Let's say personal injury, not necessarily must be car, not car. Okay, it can be he fell down, okay, personal injury, or drove the automobile off the road, okay, run into a tree. Okay, so it is all this okay, it includes all this okay. So if let's say you see the client whether he's telling his story, okay, very straightforward, okay. If the client is very vague or evasive, okay, as how the accident happened, then you can be sure that the rest of the case might be difficult. Okay, then you might reconsider whether you want to act for this client or not. Okay, liability for accident at this stage, at the interview stage, you can already feel, okay, at this stage, okay, whether who's liable actually. Is client liable, or does client contribute to the accident? This all also is a factor. It's a factor, yeah. Next slide. Okay, where? Okay, where? Because this one will determines the applicable law, jurisdiction of the court, where you want to file a claim. Okay, and then next slide. What injuries occur? This one you need to clarify questions, okay? Because client, they would like to dramatize their injuries. Okay, when they use permanent nerve damage or catastrophic injuries, what they do actually mean, okay? This one you may have to refer to the report lah. Usually they have their medical report, okay? But if they go for x-ray, go for what scan, they'll have the report. So you need to hear, okay, what the report says. Then you need to read what the report says, okay? Okay, terrible injuries. What do you mean by terrible injuries? Okay, catastrophic injuries. You need to see, okay, what actually is the catastrophic injuries? How catastrophic it is. Okay, so the same means is also injuries, and also, okay, the effect lah. Okay, terrible injuries. They have been off work for 2 weeks. This one will be relevant also. Okay, you can determine if the injuries are serious, okay, or if the injuries are likely to progress. So this one is important, okay, to determine, because it will involve the damage, okay, the damages that you're able to claim, how far you can, because in torts, you're going to claim under tort, okay, so it will involve damages, okay, general damages, how far is this extent of the injury going to be? Serious or likely to progress, likely to be worse, okay, later, or will be better, okay, will get better later. This one will be, you can determine from the diagnosis lah, okay, the report. You may have to ask the doctor as well, okay, or the medical expert as well, okay, to determine how the injuries, okay, how serious are the injuries. Okay, next slide. So physical client's current physical condition. Okay, this one also will go to the extent of the potential damage lah. Will be permanent or will take about 1 year to recover, 2 year recover. So these are the condition. Okay, because this will enable you whether you are eligible to claim for general damages. General damages will normally include pain and suffering, right? And also loss of amenity. And because of the injury, you cannot use, okay, let's say use the car, the car is out of use for 2 weeks for repair, okay. So these are loss of amenity, which are included in the general damages. But general damages, as you know, you have to prove, okay, so you have to prove it. So that's where you have to ask client what's the condition, ask for medical expert and the medical report. Next slide. So this one also very important. Were there any witnesses? Okay, let's say if like car accident, at that time there are witnesses there. Okay, this one will help you take control of important liability. This one will where the liability you need to establish one. Okay, if the accident is serious and there are witnesses to the accident, so you will want to quickly get hold of those witnesses, whether they are willing to testify for you. Okay, so from the facts, advise client on liability and cause of action, process of legal action, estimate length of time, fees and disbursement. Okay, so this is usual. You whatever process, whatever areas of practice you need to explain to client. Okay, liability, okay, cause of action, process. Okay, what procedure will be involved, estimate length of time. Client will always ask, okay, how long this will be, okay, how much it will cost, okay, fees and disbursements, okay. That's there where you give, okay, you provide all this information, and then it's up to client whether they want to appoint you at this stage. Okay, if yes, again, like the family matters, you still prepare retainer agreement and the warrant to act. Okay, and also you need to communicate with client for further information as needed. Okay, to file your court papers. All right. Any question before this, before we go for the next one? Okay, if don't have, then next matter. Next slide. Okay, for employment matters. Okay, employment, there will be sub. Okay, I'll go to sub causes lah. Okay, right. For unfair dismissal, usually employment there will be unfair dismissal lah. Okay, or they are at the threat of being dismissed, or already being dismissed, or just being dismissed. So as usual, okay, you get client to tell the story until dismissal. But remember, it's not a chat, okay? So you still have to extract the relevant details. What are the relevant details? Always check client's employer. Okay, this one is very, very important for employment matters to decide whether there will be conflict if you have to act for client. Let's say if his employer is a bank, is our bank, is our panel bank, then sorry lor, normally we won't, okay? We won't act for that client. If there's no conflict, okay, after checking indeed there's no conflict, then you check, okay, what his occupation and his salary. Okay, this is important because this will determine whether his matter will be covered under the Employment Act or under contract. Okay, do you know whether what criteria he will be covered under Employment Act? Anyone here want to try? Okay, if his salary is below 1,000, okay, 2,000, and then or his nature of work, okay, if he's totally manual, so no matter what his salary, he will still be covered under Employment Act. Okay, so if otherwise than that, it will normally be under contract lah. Okay, next slide. So you have to determine the reason for his dismissal. Let's see if he dismissed, then you have to ask him, what's the reason for your dismissal? Normally, there are 3 common reasons lah: misconduct, poor performance, or under disguise of retrenchment, okay, or restructure, or you call it redundancy. Okay, next slide. So we go through one by one. Misconduct. Okay, these are things that you need to know from, you need to get from client. Okay, circumstances of misconduct. Okay, ask you what happened. Okay, what did the company do? What do you do? Okay, you also need to get the basic information. It's date of commencement of employment. This one you can see from the letter of offer. Yeah, it's offer letter or contract. Okay, any show cause letter and what his reply, whether any domestic inquiry or outcome. Okay, whether any prior complaint of misconduct. Okay, let's say before this alleged that leads to his dismissal, is there any prior complaint before that? Okay, when is date of dismissal? This one is important because this one will decide, okay, whether he's still in time to file his complaint. Okay, reason given for his dismissal, client's response, okay, the client appeal, okay, the client write back, okay, he deny or give his explanation or ask for, okay, anything, any response lah. Then the client bring his case to DGIR, because some client like they call us, they call us after, okay, he has referred the case to DGIR. So some have just been dismissed and never done anything yet, have not done anything yet. Okay, so if it's not case, then we advise him to go to DGIR if he has a case lah. Okay, so has client been employed after dismissal? All this you get to know. You have to get information on this. Whether after his dismissal he managed to get a new occupation. What is the new occupation and the salary? These are all important because this one is needed to decide on the back wages if he bring the case to industrial court later. Next slide. Okay, so poor performance. Okay, poor performance is slightly different from misconduct. Misconduct is that he can be a good performer, but his conduct is not appropriate for the working environment. Okay, it could be sexual harassment, it could be violence. Okay, he can be a good performer, but this one, he has no misconduct. Okay, but he just performed not to the expectation of his employer. Okay, so you need to get the circumstances of that poor performance, what happened. Okay, get him to tell a story, and then of course when he started. Okay, and the salary, yes. Okay, I forgot to put that. Okay, whether client has clear job scope and expectations. Okay, whether he's clear from day one that what he's supposed to do. Okay, what is the expectation of his job? Okay, whether he's still at that point of time when he interview. Okay, when his dismissal, he's still a probationer or a confirmed employee. Okay, this one will determine whether he will get the back wages. Okay, if he bring his case to tribunal, there's a difference there. Confirmed employee, back wages different from probationer. Okay, whether any feedback of client's performance before he was being sacked, okay, or suddenly just receive a notice of termination. Okay, so whether there's any opportunity given for improvement from the employer. This one is also very important. Okay, this one you will need to be proved by the employer that they have given opportunity. Okay, but for the claimant, that means for the employee, he may say that no, suddenly they just give me a termination notice, no opportunity given for improvement. So there will be quite a clear case for the case to industrial court. Okay, so date of dismissal also important, whether he's still in time to file. Okay, 60 days from the date of his dismissal, you have to bring the case to DGIR. Okay, reason given for dismissal. Then client's response. Okay, reason given is also important, but it's stated in the letter of termination. It could be complaint is poor performance, then dismissal is another reason, then there's no connection already. Okay, then did client respond to that dismissal? Did he write an appeal letter or complain or deny? That also important. Okay, all this, if there's any document, you also have to get. Okay, next slide. Did client bring his case to DJR before he consulted you? Okay, so if client has been employed after dismissal, this one also need to determine whether his later his back wages, if he wins the case, again the new employment and the salary. Okay, so this one, poor performance, you of course, okay, this sounds like easy, but in the between you need to get the quite other information, especially go back my okay, circumstances of poor performance there, whether the email lah, okay, whether complaint lah from management or complaint or from staff or colleagues, any email or any letter, black and white evidence, all these are very important. All this you need to get documents also from the client. Okay, so that's for poor performance. Next slide. Next slide. Okay, if this one, a third category, is under the disguise of retrenchment. As we know, yes, okay, like this time COVID-19, there's a increasing cases of retrenchment of workers, okay, on the grounds of being redundant because they are no longer needed, and then they are being asked to leave. So you still need to get, okay, the commencement date of employment and salary, their occupation, okay, in their employment contract, whether they are confirmed or probationer, and then circumstances that lead to retrenchment. So whether there's evidence of reorganization, this one all you need to get. Okay, if there's documents you need to get from client, it could be a memo, it could be a letter from client and from the employer, okay, from evidence whether they say we are currently going through organization. Okay, because this is important, whether this will affect the client's function, okay, will reduce and be considered redundant or because of the reorganization. So this one, does whether there is evidence of reorganization and whether the reorganization affected client's function, okay, and whether the employer got any criteria in retrenchment. We know that there is there's this code, okay, code of what's that code? Code of what? Conduct harmony. Okay, that they lay down the code, okay, where what the employee have to follow. Okay, what's the criteria in retrenchment? Normally it's the LIFO, okay, that means first last in first out. Okay, the latest who come in, they were first to leave. But it's not necessary that employer follow this retrenchment lah, this criteria. Okay, so we need to know what's the employer's criteria in retrenchment in that client's case. Okay, or they just random, or they just you know, after like they take over a company, they lay off they keep all their employee, and then they they lay off all those from former companies, the companies that they take over. Okay, this one happened in a lot of cases. Okay, whether they notify, the employers notify labor office of retrenchment. This is required under the termination and layoff benefit, but this one is for those covered under the Employment Act lah. They need to notify labor office. Whether there's any elements of bad faith, okay. Bad faith, it could be, let's say they are quite biased, let's say can be biased, okay, like element of bad faith, that means company A take over company B. Company A's all employers, they lay off, they keep. Companies B's one, all they want to lay off. So that's criteria, is you can say that's one element of bad faith. Or they only approach you, okay, one person, but you know, the other person in, the other department is still there, okay, or that means they approach particular person only. So that can be element of bad faith. Or they say they're no longer redundant, they no longer need you, but okay, after they serve the notice to leave, and then they hire another person from okay, the same position. So okay, so uh, that's an element of not say bad faith lah, but it's not in good faith. You can say it's not in good faith. Okay, you're not genuine reorganization. Okay, and not genuinely redundant. Okay, so these are very factual. Okay, you have to extract it from client story. That's why you need to see what happened. Okay, circumstances that lead to retrenchment. You have to ask you to, from there you have to decide whether there's any elements of bad faith. Okay, next slide. Whether client receive any termination benefits. Okay, if it's covered under Employment Act, there's a table there. Okay, how much termination benefits, okay, according to the year of service. Then from the facts, then you can decide whether the retrenchment is justified. Okay, you see, generally companies, they have this privilege, okay, because it's their company, they can go for reorganization, they can go for restructure, but provided they do that in good faith. So you must catch hold whether there's any elements of bad faith. If it's justified, they are justified to lay off company, then there may be no cause of action. Okay, but if it's not justified, that means there may be a cause of action, there may be an element of bad faith, then you advise client to file representation in the to the DJR. That means client is an unfair dismissal, but they are disguising it as redundancy. Okay, so that's you have to again explain to client the whole process. Okay, when you file DJR, okay, whether we can conciliate, then after that you have to wait for the industrial court, okay, to start your case. So there's estimate length of time. It can take quite some months to dispose the case. Okay, estimate length. Okay, estimate fees. Okay, that's where you can propose your fees. Okay. Then if client agrees to appoint you, then you prepare your retainer, same, okay, and warrant to act for client to sign. Okay. Right. Is there any question before we end the session? Next slide ada tak? This one is usual lah. Okay, you need to familiarize. This is the one, the code of conduct of industrial harmony. Okay, this is a code. Of course, it's not gazette. Okay, it's not law. So, but it's a code that where you need to best practice lah. That means a company is advised to follow the code. Okay, so this code will they provide for the guideline for retrenchment exercise, what companies need to do. Okay, and also the Industrial Relations Act. This one also very relevant. If client decides to go for unfair dismissal, okay, to file his case in the industrial court, that's where you need to be familiar with this industrial relations, particularly like section 20, section 30, okay, of the IRA. Okay, I think there's no more slide. Okay, any questions? Okay, you need to clarify. Any one of you, can I ask, any one of you have answered any queries when the client, any caller they call to ask questions, general inquiry? No? No. Okay, because these are the very common questions that client ask. They ask this type, especially employment and family type. Okay, these two questions, and these are the questions that we keep asking. Okay, if any of you pupils, okay, let me just give my piece. of advice. You eventually will be practicing, okay? And then it's best to start, okay, with your general inquiry, okay, your interview client during your pupil stage. Last time when I was still pupil, I was already interviewing clients, okay? So because my master was, okay, he leave all this to me. So I will have to do my practice. Okay, so that's the stage where I do practice. Okay, even though it's first time, it may not be a good experience, but it's always good to start early. Okay, so if any one of you pupils would like to be exposed to this try to answer general inquiry, okay, you can let me know. Okay, I can arrange that. Okay, I can arrange that with the reception. Okay, so feel free if you want to get further guide on this. Okay, if there's no question, thank you. I thank you for attending. Okay, bye-bye.
Thank you, Miss Tan.
Okay, bye-bye.
Thank you, Miss Tan. Bye-bye.